You feel that a doctor failed to diagnose your cancer in a timely manner, and as a result of that, you suffered significant harm and injury as a result of that. And now when you're questioned during the course of your deposition, the defense attorney turns around and asks you, Mr. Jones, why did you choose to bring a lawsuit at this time? Do you have to give an answer? Would you like to know the answer to this question? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now here's the scenario. You're now bringing a lawsuit or contemplating bringing a lawsuit because of a failure to diagnose cancer. And as a result of the delay of the doctors and the hospitals timely diagnosing your condition, your cancer has now spread. And you've chosen to bring a lawsuit, or you're thinking about bringing a lawsuit. And now you're worried if you go ahead and do that, when you are now being asked questions by the defense attorneys about what happened to you and at what problems you have as a result of that, that's known as a deposition, which is really pretrial testimony given under oath. Are they going to ask you the question about, hey, Mr. Jones, Mrs. Gonzalez, why did you choose to bring a lawsuit against my client, the doctor? Tell us why. First of all, is that an appropriate question? And second of all, do you have to answer that type of question? There is absolutely no right for an attorney to ask you such a question, and in my opinion, such a question would be palpably improper because the motivation for wanting to bring a lawsuit to seek compensation is an inherent right that you as an injured victim have. And in my opinion, you never have to answer that type of question to explain away or to justify to a defense lawyer who's representing the people that you believe are careless and caused and contributed to your injuries. In my opinion, that would be a palpably improper question, and I would direct you not to answer that question during the course of your pretrial testimony. Now, a judge may, at trial, invite you to go ahead and answer that question. And you know what? At trial, that might be an appropriate thing for you to turn to the jury and explain to them your rationale for your motivation for bringing a lawsuit. But during the discovery process, that, in my opinion, would be a totally improper question, and I would turn to you and tell you that that is a palpably improper question. The defense knows it, and they're basically fishing for information. So why do I share this quick tidbit of information with you? I share it with you to give you an insight and an understanding into what goes on during the litigation process in a medical malpractice case here in the state of New York. You know, I realize you may be contemplating bringing a lawsuit and you have questions. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is what I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.